Thank you for viewing this brief presentation about two landmark cases that set the precedents for legal decisions regarding defamatory allegations. The first case is New York Times versus Sullivan. In this case, the parties are plaintiff L.B. Sullivan and the defendant is New York Times Corporation. The article, Heed Their Rising Voices, is what led to the dispute. The New York Times ran this full-page advertisement, which gives information about the bad things that are happening to civil rights movement participants in the South, particularly at the hands of the police. It includes names of civil rights leaders who support the advertisement, but not the names of the people who are taking actions against the participants. Even though the article does not mention him by name, Sullivan felt that the article was about him since he was a police commissioner. He sued the New York Times Corporation for defamation. Because the plaintiff was a public official, he had to prove actual malice. This means that the defamatory falsehood relating to his official conduct was made with the knowledge that it was false or with reckless disregard to whether it was false or not. The jury ruled in favor of the plaintiff, and the Alabama State Supreme Court agreed, awarding Sullivan $500,000. The New York Times Corporation took the case to the U.S. Supreme Court. The U.S. Supreme Court judges everything against the U.S. Constitution. In this case, the First and 14th Amendments to the Constitution were involved. Basically, freedom of speech. The plaintiff was unable to prove actual malice. To the issue, is the defendant liable for defamation for printing an advertisement which criticized a public official's conduct? They ruled no, reversed and remanded. The U.S. Supreme Court felt that this case would hurt the First and 14th Amendment applicability. The Constitution delimits a state's power to award damages for libel actions brought against a public officer while conducting official duties. The next case, Kurtz versus Welch, is also a landmark case. The petitioner is a private person, Elmer Kurtz, and the respondent is the American Opinion magazine publisher, Robert Welch. An article was published in the American Opinion basically stating that Elmer Kurtz was a communist and had a criminal record. It alleged that he was a member of the Marxist League for Industrial Democracy, or the Intercollegiate Socialist Society. Although Welch did not write the article, he published it. Even though the New York Times versus Sullivan case set the precedents for media-related defamatory statements, it could not be applied to this case. The difference is that Sullivan was a public officer and Kurtz was a private person. It was determined that a private person does not have to prove actual malice, but negligence. What Welch did was proven to be negligent. Welch did not investigate the allegations prior to publishing. He did not confirm the allegations. Welch stated he just went on the writer's past works and reputation. This is not something I would have done. I would have asked the writer, whose name is Slang, what sources he got this information from. It takes time to build a good reputation and only a few moments to ruin it. The media has a responsibility to be honest and truthful. This is how we gain the public's confidence. Gertz was not a public figure. He was a lawyer in Chicago, a private person. I think this article hurt his reputation with friends, family, and clients. Even though the defamatory statements were false, people have a tendency to believe what they read and see in the media. Gertz was a private person who did not have the privilege or opportunity to defend his reputation with all the people who may have read the article. This is one of the reasons behind making the distinction between private and public figures. In the state of Virginia, the defamation law makes a distinction between a private person and a public figure. First of all, any defamation charge must be based on a published false statement that harms the plaintiff's reputation. The private person must go by the negligence standard unless the substantial danger to reputation is not apparent, in which case the actual malice standard applies. The public figure must prove actual malice. The Sullivan and the Gertz case have made me think about what I say and write. The statement, "If it cannot be verified, it cannot be published," is my new motto. As I pursue new media journalism, I will publish only what I verify. I will also study more about the legal aspects of journalism and the responsibility of the field itself. Freedom of speech has limitations when it comes to speaking about other people. I'm Nancy Dabney. Thank you for watching.